Hi, it's Mike DelSignore. In today's video, I want to talk about what happens if you're charged with OUI and it's your second offense. The case is going to be heard in the Plymouth District Court. So second offense OUI, we have two types of second offenses. Basically, the first one, your two OUIs are outside of 10 years. So they're a long time ago in the court's view. If they're within 10 years, then it's basically a standard second offense where if you had refused the breath test and your two OUIs are within 10 years, you got a hard 3-year suspension. The only way realistically you're going to get that overturned is to be found not guilty. Additionally, if you admit to a second offense and they're within 10 years, you're going to have to do a 14-day inpatient program. Depending on how close together they are, you could be looking at jail time. Typically on second offenses, most of my clients have not received jail time either after trial or on pleas, but it is possible. So it's certainly not something you can say that there's no chance or ignore the chance, but generally speaking, I haven't had too many clients get committed time on a second OUI. Now, what happens if those two OUIs are outside of 10 years? Then there's sort of more options, basically. If you refused a breathalyzer and you resolve the case with the 24D program, you can get what's called the Cahill disposition. Sometimes it's referred as the second chance first offender, where you can get your license back, but you're going to have to get an interlock device in your car. You'll have it for a hardship period for the 3 years plus 45 days plus another 2 years. So it's a long time with the interlock device for sure, but it lets you back on the road. If you took a breath test and failed, you can get back on the road. Similarly, interlock for 2 years. So you're looking at a potential shorter license suspension. Now you need to get the Cahill resolution. I would say on a plea, most judges are going to approve that, but a judge can give you the standard second offender penalties, and then you won't be eligible for that lighter resolution of the case. In other words, if the judge treats it the same way they would treat it as if your offenses are within the 10 years and gives you a 14-day program, assignment to the 14-day alcohol education program, you're going to be looking at a 3-year license loss if you refused and a 2-year license loss on the OUI conviction. So with the Cahill resolution, the judge has to treat it like a first offense, give you a 24D program as part of the resolution. So in other words, your penalty would be 1 year probation, complete the 24D program, 45-day license loss. So basically be the same penalties as for your first OUI. So those are the potential license consequences, different ways we can handle second OUI. Keep in mind with any OUI offense, it's hard to prove these cases beyond a reasonable doubt. The government needs to prove the case to an abiding conviction to a moral certainty, a near moral certainty. That's what it means to have proof beyond a reasonable doubt. It's a lot of proof. In other words, it's not enough just to say, well, you might have been under the influence, you could have been. The government's got to prove it. So why is that so difficult with OUI cases? It's because these are very subjective cases. There are a lot of reasons why you might not have performed perfectly on field sobriety tests that don't pertain to alcohol. You could have been nervous. It could have been the weather at the time. It could have been your medical conditions. It could have been that the officer really just didn't give you credit for what you did right. In most reports, the officers don't include what you did correctly. They only put the bad details or the negative details in the report. When I speak to clients, I'll let them know what they did right, how those facts that aren't mentioned in the report support the argument that you were not under the influence and we can use to raise reasonable doubt. I've read many police reports and can go through the reports and show you where the strengths of your case lie and where we might have some issues where we might want to think either how do we deal with this or if they're substantial enough about a potential resolution of the case. But field sobriety tests, often the reports are very lack detail. I've seen reports where they say the person put their foot down, the one-leg stand. Well, when? And usually if there's no detail about when it was, I'll argue to the judge or to the jury and even have the officer admit that the person may have put it down but put their foot back up. So these vague reports that you often see on field sobriety tests, they help you. Don't assume you can't win your case just from reading the report. I've read hundreds of reports. I handle these cases every day. I know many of the officers, and I'm familiar with the courts, especially in Plymouth District Court and courts throughout Massachusetts. So call, text anytime if you want guidance on how to make the best decision for yourself on a second OUI in Plymouth. My cell, 781-686-5924. My name is Mike DelSignore, here to help.